Greetings. Greetings. This is Attorney Della Welch, and this is the second recording on the subject of contempt in family court in California. The last recording ended with the situation where the judge dismissed the contempt, didn't find they met their burden beyond a reasonable doubt, released the respondent from the subpoenas and from the contempt. However, let's look at the situation where the judge does find the respondent in contempt. The judge may find that the wife or Mrs. Doe elected to do nothing about the court order. If a wife disagrees with the underlying valid court order and thinks it is wrong, that is not enough to willfully violate that. If the court finds that the burden has been met beyond a reasonable doubt, he or she will turn to the petitioner or her counsel or his counsel and say, "What do you want me to order?" Usually they order community service. I was on a recent case and the judge ordered 12 hours of community service because the petitioner asked for 12 hours of community service. The judge gave that person until June 1st of 2022 to complete the community service, which is often picking up trash on the side of the freeway or on the side of the road. But she said, if this person does not complete it by this date, then the person would have to spend 2 days in the county jail. So often jail is a backup. So if you're the petitioner, you have to be prepared to tell the judge what you want as the punishment. Do you want them to go to jail? Do you want them to pay a fine? Do you want them to have the community service? Now, looking back at the hearing, there are certain cross-examination questions that attorneys may ask the petitioner to try and discourage the petitioner from bringing the contempt action. They will say, if the judge orders community service for your wife, this will limit the time that she has with the kids. Is this okay? Remember, in court, answer yes or no or I don't know. Don't magnify or amplify your answers. They may ask you, when you filed the contempt motion, you knew your wife may do jail time, and you can say, yes, this would be okay. You understand that by its very nature, contempt is very serious. Isn't that correct? Yes. And you have filed these serious charges against your wife. Isn't that correct? And you'd say yes. You understand it's quasi-criminal in nature. Isn't that correct? And you can say yes. Remember, on cross-exam, the other side can ask leading questions. Leading questions suggest the answer. And you can indicate you understand that his or her client may do jail time. And you can say yes. You understand this is for punishment. Isn't that correct? Yes. And you understand that it will not change the underlying order. Isn't that correct? Yes. So you do have to show that the other side had the ability and simply chose not to. And you have to build the evidence for your case. If you hire an attorney, the going rate is about $500 an hour. Now, the good news is if you win the contempt, you may be ordered to have your attorney fees paid. if you lose, then the other side will find that you need to pay their attorney fees. So that often is a big issue. So it's important to study this area. There's a lot of information on Google. I call it YouTube University, where you search the term contempt of court, and make sure that you have a valid order, not a vague order. Make sure that the other person knew of the order, they were present in court, but they chose not to follow it. And make sure that you have proof that they were served with the underlying order, such as a child visitation order, which they violated. And you have to prove that it was willful. That is the hardest part, but it's not impossible. So I always say the attorney that wins and the party that wins is 5 minutes better than the other side. So hopefully you will listen carefully to this recording and study the material. And an excellent reference book is the Rutter, R-U-T-T-E-R, book in family law, which covers all subjects, gives you the forms, how to fill out the forms. Remember, an attorney is a form filler-outer. First, they have to be a librarian to find the form, and then they're a form filler-outer. These courts are public courts, so you can go in court and watch these contempt hearings. Also, Riverside County Superior Court has their recordings on audio and video. You can go to their court site and look at that, and then listen. Practice makes perfect. Listen to these contempts, because it is very serious. You can't play with jail, and this is the most serious motion. But those people who do thumb their nose at the court's order need to be held accountable. So hopefully this will help you in preparing for your contempt trial in California.